Shopify's point of sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.
Look, to be fair, Baldoni's complaint is realer than Robinson's, and he certainly has experienced counsel. Baldoni, that is. But to me, it reads as yet another PR ploy, a way to kind of get the media to cover his side of the story and make it a he said, she said thing, which I don't think is going to work for reasons that we'll get into. Welcome to Law and Chaos. Today, we'll talk about the Blake Lively, Justin Baldoni lawsuits and why you should not show your coworker nude images of your wife. No, not even if she was in labor at the time. And subscribers will get the funniest Rudy Giuliani update ever. We got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you? Happy New Year.
Happy New Year to you. Did you have a good time?
I did. And you?
I did. I had one or two glasses of wine. Maybe I was feeling a little tired on New Year's. I still wrote our post. I still did my job.
I will not tell anyone. So that makes this the perfect time to mention that latest blog post, which is entitled, Please Keep Shit-Talking Judges. We'll link to it in the show notes. And remember that if you are a Patreon at any level, you get the reposts of all of our written content simultaneously on Patreon as well. So if you support us in that way, you do get all of our written content. And this piece, this is Liz's, was about John Roberts' State of the Supreme Court memo that he writes every year. And look, they're always self-serving and terrible, but this one is extra strength terrible, right? As he is trying to admonish journalists, like us, into both sidesing obvious political hackery by saying, oh no, we judges never do that. And when you insinuate that we're acting out of partisan motives, that makes the law we do worse. And what bullshit.
Yeah, no, I guess I sort of take a little bit of issue with that. I think his lecture was more toward like, hey, lawyers, defend us. Keep saying that the institution of the judiciary is still legitimate, despite the fact that it's like, totally delegitimized itself and don't demand that I, as a journalist or as a lawyer or anything else, as an American, prop up the judiciary as it's beclowning itself in grossly partisan fashion. And yes, one of the things that he pointed to was people criticizing Judge Eileen Cannon, which is amazing. Anyway, I didn't get to this in the post, but his last example of intimidation after he said all of the, criticizing judges and saying they should be impeached, his example of intimidation was people saying that they would defy the court's rulings, which, like, my dude, you know who has promised to defy the court's rulings on day one? That would be Donald Bloody Trump, who says he's going to repeal birthright citizenship by fiat. And thanks to you, Chief Justice John Roberts, that guy has zero incentive not to defy the courts because you 6 assholes told him he did not have to follow the law and there would never be a consequence. So There you are. Anyway, so it's a new year and we are going to tweak the format a little bit, starting with a new segment we'll be calling Docket Alerts, just to flag stories we're following that won't get a full segment, or at least not today.
Yeah, there may be a lot of these in the near future, so I think this couldn't be more timely.
Right. So first up in Docket Alerts, Texas Attorney General Ken Paxton filed an absolutely vile troll suit against the NCAA in the District Court of Lubbock County. He works from the proposition that trans people don't exist. They're not real. They're like Sasquatch. And so it violates Texas's consumer protection law to allow, quote unquote, men to participate in women's sports. Ugh. It is already illegal in Texas for trans athletes to play sports, but Paxton is trying to make the rest of the country play by his demented rules or not play or something. I do not understand the basis of this lawsuit other than to just be a performative asshole. He wants the NCAA to bar trans athletes from participating in intercollegiate games where Texas athletes are playing. Or alternatively, he wants the NCAA to out trans athletes and not advertise any event in which they participate as a women's sport.
Yeah. This reminds me of our conversation on New Year's Eve with Evan Hurst, right? Like, this is a solution desperately in search of a problem, right? So NCAA President Charlie Baker testified to the Senate that there are 570,000 NCAA athletes and 10 of them are trans. I get to quote Willy Wonka, like, I can't figure out a percentage that's small, right? Like, this is just performative cruelty, and it helps none of his constituents in Texas, right? This is a colossal waste of taxpayer money by a freaking weirdo who does not care about women's sports and is obsessed with kids' genitals, and that's weird.
Right. And that's the way it should be dealt with, right? Say, like, what's wrong with you, you weirdo, and who are you helping? But I would just like to say it's worse than a problem in search of a solution, because Paxton resorts to outright lying to make his point here. Mm-hmm. As you said, there are virtually no trans athletes in American colleges. So Paxton picks on a bunch of professional women athletes, including the runner Caster Semenya, who is intersex, and Duty Chand, an Indian runner who is submitted to invasive gynecological exams to establish that, yes, she is a cisgender woman whose body just makes high levels of testosterone. And then Paxton talks about the boxers Imani Khalif and Lin Yuting. Khalif is Algerian. She was at the center of that international firestorm after she beat the Russian champion boxer, only to be disqualified 3 days later by the Russian-led International Boxing Association. They got caught kind of lying about those tests. Mm-hmm. First they said it was chromosomes, and then they said it was something else, and whatever. Like, it's not really our business. The International Olympic Committee eventually stripped the IBA of its accrediting power, and Khalif and Lin, who is from Taiwan, both went on to compete at the Summer Olympics in Paris. Now, here's how Paxton described that in his nasty complaint. He says, Imani Khalif is a male with disorders of sexual development, DSD. Not only was Imani a male, he fought against another male boxer with DSD, Lin Yuting, in the final round of the women's boxing competition at the 2024 Olympics. The IOC's actions, like those of the NCAA, ultimately left consumers confused, angry, and feeling cheated after they purchased goods and services associated with women's boxing, thinking that they were supporting women's competition, only to witness men fighting women and ultimately two men fighting each other over the gold medal. The problem with that is that it never happened. Khalif won the gold as a welterweight and Lin won the gold as a featherweight, and they fought, indeed, both of them at the Paris Olympics in the summer, but they did not fight each other, which is hardly the point. But still, Paxton's argument says everyone knows what is woman because women are born girl babies, blah, blah, blah. And you know what? All four of these athletes were born as girl babies. They lived as girls their whole lives. They competed as women for their entire athletic careers. And he's scrutinizing their blood tests and saying, oh, no, you have elevated testosterone levels. You're actually a man, no matter your biology. And those two things can't both be true. Either you were born a woman and you're always a woman, or, you're not, because some sort of way you go through puberty and you have extra hormones and then you become a man. It is, okay, it's gross.
Yeah, it is incredibly gross and I hate it. And let's move on. So more bad news from the Sixth Circuit, which struck down net neutrality this afternoon as we record this on Thursday. Yeah, net neutrality is the principle that internet service providers should treat all traffic on the internet equally, right? Essentially that it should be a dumb pipe, right? And not throttle disfavored content, like, say, pornography, or content that eats a lot of bandwidth, like, say, pornography. But look, more to the non-pornographic point, right? The point is that allowing carriers to have fast and slow lanes for the internet is super bad for consumers because everyone needs the internet to live and work, right? And you wouldn't want, let me pick a company at random, Tesla, to be able to opt in for preferred access 5G tier that everyone else gets locked out of because of the pricing, right? So under Obama, under Democrats, right, the FCC implemented net neutrality rules based on the understanding that internet providers were common carriers that should be equally accessible to everyone and were subject to FCC regulation. And the DC Circuit upheld those rules in 2015. Then we switched parties as president, right? Donald Trump came in. He killed the net neutrality rules, which the DC Circuit also upheld in 2018. Then we switched parties again, and Joe Biden reinstated them. And you would think all of this would be fine, right? The whole idea of electing a president is you hold them accountable for what their executive branch.
Elections have consequences.
Right. But no, because the Supreme Court has now killed Chevron deference, the courts are free to take a big old red Sharpie to any agency regulation they don't like. And lest you think I'm overstating this, let me read you a bit from this opinion, because it's a double win. The court says, the safeguarding order once more imposes net neutrality policies on broadband internet service providers by reclassifying broadband internet as a telecommunications service subject to common carrier regulation under Title II. This order, issued during the Biden administration, undoes the order issued during the first Trump administration, which undid the order issued during the Obama administration, which undid orders issued during the Bush and Clinton administrations. Applying Loper-Bright means we can end the FCC's vacillations. And look, that makes me incandescently angry, right?
Yeah.
Because vacillate, or what we just described, that's what the executive branch does when you change president. And what the Sixth Circuit is doing here is weighing in on one side, right, Trump's side, against the Obama-Biden position, where that is, to call back to our previous segment, obvious partisanship. And by the way, the Sixth Circuit has jurisdiction in just 4 states. Right? Ohio, Tennessee, Kentucky, Michigan. But apparently they can now gleefully say, hey, we put a stop to the government doing things for 375 million people because of a complaint filed in East Murfreesboro or wherever. I'm so mad. Anyway, here's the holding. In the panel's view, whether broadband internet service providers are Title II common carriers and subject to net neutrality policies is likely a major question requiring clear congressional authorization, and the Communications Act does not plainly authorize the commission to resolve this signal question.
Christ, it's like a Mad Libs of imaginary legal doctrines, which are somehow real thanks to Chief Justice intimidation. Okay, we will probably get into this one in depth in a future show, but basically the D.C. Circuit in 2015 and 2018 referred to the reasonable agency interpretation of law, where the FCC said, we get to regulate internet providers because they're a common carrier. But since SCOTUS killed Chevron deference in Loper-Bright, there is no deference anymore, and so we all get to have crappier, tiered internet thanks to the Sixth Circuit. Hooray! But it is not all bad news. It's mostly bad news, I'm not going to lie to you there. But on New Year's Eve, the Second Circuit affirmed the holding in the first E. Jean Carroll case. That's the one where Trump didn't show up and wound up with the $5 million verdict. That's not the one where he did show up and got an $83 million verdict because juries love him.
Yeah.
Anyway, his lawyers John Sauer, Todd Blanche, and Emile Beauvais, a.k.a. the future Solicitor General and number 2 and number 3 at the Justice Department, argued that the trial judge erred by admitting propensity evidence, that's evidence of the defendant's likelihood to commit sex crimes or likelihood to commit a similar crime, but the laws are very specific about propensity evidence in sex crimes cases. Mm-hmm. They've been making this dumb argument for years. Literally, they claim there was no sexual assault because Trump grabbed and groped these other women who testified at the trial, but he did not manage to make contact with their genitals. I shit you not, that's his real argument. Plus, one assault occurred on an airplane, and that doesn't count. And the Second Circuit said, shut up, no, go away, which is pretty much dispositive, not only in this case, but when Trump goes to appeal, or he is actually currently appealing the $83 million second verdict. Mm-hmm. It's the same fact pattern. So too bad, so sad.
Yeah, you love to see that. So, speaking of Sauer, he has also filed an amicus brief on Trump's behalf in the TikTok case. That's the ban because TikTok is Chinese owned, and that, unless the Supreme Court does something, goes into effect on January 19th, one day before Trump becomes president. And this is just not subtle, right? Here's the ask in the brief. In light of the novelty and difficulty of this case, the court should consider staying the statutory deadline to grant more breathing space to address these issues. The Act itself contemplates the possibility of a 90-day extension, indicating that the 270-day deadline lacks talismanic significance. Such a stay would vitally grant President Trump the opportunity to pursue a political resolution that could obviate the court's need to decide these constitutionally significant questions. And look, there's a lot here, but as we told you in episode 90, that is not at all a correct summary of the TikTok ban, right? Like that 90-day extension is only if there is an explicit congressional statement that a sale of TikTok is underway. And there is no such sale, right? So, and the idea that the deadline for the law to go into effect is talismanic, right? It would be hilarious if this were not so craven, right? Like, because remember, the DC Circuit's basis for upholding this law in the first place, in strict scrutiny, right, despite the fact that it clearly violates the First Amendment, was urgent national security crisis. So, something can't be an imminent threat to our safety and security and also be like, get to it when you get to it at the same time. Like, those two things are in tension. Anyway, we all know what's really going on. Here's how tech journalist Kara Swisher shared her theory on BlueSky. She says, my single prediction for 2025 in tech, Trump is asking for the delay in the ban or forced sale of TikTok going into effect so that Elon Musk can make a bid for TikTok, probably with involvement from Larry Ellison again and other Twitter investors again, in order to turn a lemon into rancid lemonade. China will cooperate. Liz, what do you think?
I don't know. I don't know if China will cooperate. I could go along with all of the rest of it. Trump did try this shit the first time. But I was always of the opinion that we had one president at a time, and you did not get to petition the court as the president in waiting, that there was a unitary executive. And that was a big theory on the conservative right. But guess not.
Yeah, I guess not. I think, look, as we have said on the show, the kleptocracy of the incoming Trump administration and how much money Elon Musk and all of Trump's cronies are going to openly steal, like, that's just going to be the background noise, right? It's going to be bad.
On the plus side, if they do destroy TikTok, we'll all get our attention spans back. Like, I am definitely much better attention span since my particular website, Twitter, got wrecked. But, okay. That is going to do it for docket alerts. We'll have to get some kind of theme music for this segment, maybe. I'll get on that. But we will be right back in just a minute with all the Blake Lively, Justin Baldoni, what even is defamation news after we pay some bills. And we are back. Okay, so briefly, for those of you Andrew's age and older.
We are the same age.
We are not the same age. Blake Lively is a famous movie star. Andrew, had you heard of her before? Pretend yes. Pretend you have. She's married
to...
Yeah, sure, okay. She's married to Ryan Reynolds, who is another famous movie star. And
there's no doubt I have seen more Ryan Reynolds movies than you.
That's true. I can't do rom-coms. I just can't. Anyway. All of this is to say she's a big famous movie star, and she still got sexually harassed on the set of a movie she was starring in. She says that her co-star and director, Justin Baldoni, along with producer Jamie Heath, created a hostile work environment on the set of It Ends With Us, which is a movie based on the novel by Colleen Hoover about domestic violence in her parents' marriage. There was major drama behind the scenes, and Lively eventually negotiated a new contract with Baldoni's production studio, Wayfair, as a condition of finishing the film. It was a writer. Basically, Baldoni and Heath said, okay, no more doing shit that would make an HR director stroke out. We pinky swear.
Yeah, which may be why Wayfair did not have an HR director. Put a pin in that.
Right. Well, so after the movie wrapped, there were subtle signs that things had gone sideways, not in a frequency that you and I could hear, Andrew. It was like Baldoni did most of his press junkets alone, and Reynolds unfollowed Baldoni on Instagram, which, but that is the sort of thing that fans noticed and did notice. So Baldoni and Wayfair, his production studio, had a bunch of publicists, including an outfit called Jonesworks LLC, put a pin in that one, and Jennifer Abel and her PR firm, RWA Communications. Lively alleges that on July 31st of this year, Abel recommended that Baldoni hire Melissa Nathan, another publicist in her firm, the agency Group PR, aka TAG, which specialized in crisis management. And the point of, going through the cast of characters is to explain how there came to be all of these text messages in the complaint about their plan to proactively plant negative stories about Lively in the press. Because they were worried that she was going to come forward and talk about the bad experiences that she'd had, the hostile work environment on the movie. And Baldoni and Heath were worried that they were going to get canceled because of it. And so they proactively move to set up a smear campaign against her so they could, if she did say that, they could say, well, you're just a bitch and you're hard to work with. Most of that is, everyone agrees about it. I mean, Baldoni and Heath don't agree that there was sexual harassment on the movie, but the renegotiation of this writer and the internet drama and the PR campaign, none of that is in dispute. And it's also not in dispute that there was a lot of negative press about Blake Lively that circulated over the summer. And those stories were shared by Melissa Nathan and Jennifer Abel with Baldoni in a celebratory fashion. They appeared to be taking credit for a lot of those stories. And then all of those texts wound up splashed across the front page of the New York Times by a team of journalists led by Megan Twohy, the reporter who first publicized the Harvey Weinstein allegations. So she's no stranger to this beat. Anyhow, all of these people are now up to their eyeballs in litigation.
Yeah. So let's unpack the timeline of events, right? So first, Blake Lively initiates a civil rights division complaint in California, apparently in mid-December, right? And this is part of a process. It is initially non-public, although the plaintiff, Lively, gets the opportunity to file an intent to sue letter and then file a public complaint later if she so desires. And again, you can see why you would want the choice to be with the alleged victim as a matter of public policy as to whether to go forward.
Right. Filing a sexual harassment claim in Hollywood is going to have major career ramifications. We all saw, stars like Ashley Judd and Mira Sorvino basically disappear because they were afraid to take on Harvey Weinstein. So, having a sealed process makes it easier. And look, it was going to be a heavy lift for Blake Lively. She wasn't trying to do this.
Yeah. So then the second aspect, we have a copy of the California civil rights complaint. We do not know if it was ever filed in state court. I'm thinking probably not, because she filed a similar complaint in federal court in New York on New Year's Eve. We're about to talk about that. But pursuant to that closed process, Blake Lively served a third-party subpoena on Jones Works LLC. That is Stephanie Jones's PR company. I know there's 5 PR companies by now, but that's how Lively got her hands on the thousands of text messages by and between all those other PR flacks that you described, right? As well as their communications with the producers, right? Usually that's the kind of thing that comes out in discovery, right? Not the kind of thing you have when you file the complaint. And look, those messages are really, really bad.
Yeah, you remember during the LIBOR scandal when the traders were all texting each other, I need some interest rate hikes on Tuesday, or in the Enron scandal where they were like, all the money you guys stole from those poor grandmothers in California. That's an actual quote.
Right. Yep.
These texts are that bad, except they say we can bury that bitch. I mean, they didn't say bitch, but they definitely said bury. These will be in that pantheon of, in the textbook, don't do this. Don't put it in writing.
Yeah, I cannot imagine the unbridled joy the Wilkie Farr lawyers experienced when they opened up that discovery file. It's a toss-up as to whether they were happier then or when they deposed Rudy Giuliani's dingbat henchman.
I'd save that for the Patreon, big guy.
All right, we'll do. Okay, so now we're at step 3, in which Lively talks to the New York Times, which then, on December 21st, 2024, published an article that we will link in the show notes titled, "We Can Bury Anyone Inside a Hollywood Smear Machine." The deck to that is, private messages detail an alleged campaign to tarnish Blake Lively after she accused Justin Baldoni of misconduct on the set of It Ends With Us. And then they publish a link to the complaint that may or may not have been filed. So after which, all hell breaks loose, right? This becomes front page everywhere. And the article seems appropriately makes Baldoni and Heath look terrible. I mean, look, Liz, you and I were never going to see the Daily Mail or Page 6 stories that the PR people were trying to plant against Blake Lively, but we're sure as hell going to see it if it's in the New York Times, right?
Yep.
Okay. Then, step 4, Baldoni runs to state court in California to sue the Times for defamation for publishing that article on December 31st, and step 5, at the same time, same day, New Year's Eve, Blake Lively files a complaint in federal court against Baldoni, Heath, Wayfair, the production company, and some of the PR people alleged to have been in on the conspiracy to destroy her in the press. She also sues Steve Sarowitz, the billionaire co-founder of Wayfair. And the reason I'm emphasizing the identical day here, because first filed is a consideration, right? Like the timestamp of the exact hour and minute when each of these complaints were filed may wind up coming into play here, right? Like, and there are a bunch of reasons why they can't be consolidated. But one of them is that Baldoni filed in state court while Lively filed in federal court. We're going to come back to all the procedural stuff in a minute.
Yeah. But first, let's talk about Lively's suit, which I should note has been assigned to Judge Louis Lyman, who has the misfortune to be on Rudy Giuliani's case as well. Look, he's an experienced guy. He'll do a good job. And incidentally, as you said, Lively is represented by Michael Gottlieb from Wilkie Farr and Gallagher, the same attorney, and I think the same team who is representing Freeman and Moss. So New York is big, but it's also small.
Yeah, I mean, not Baltimore small, but
fair.
I take your point.
Yeah. So Lively alleges a whole host of wildly inappropriate behavior by Baldoni and Heath. She says that Baldoni added a bunch of gratuitous sex scenes, that he kissed her repeatedly and in scenes where it was not scripted, and that he failed to follow industry guidelines for sex and nudity, including shooting without an intimacy coordinator and without closing the set. I'll just read you one insane passage. Please forgive the length. It just it just couldn't be stopped. On the day of shooting the scene in which Miss Lively's character gives birth, Mr. Baldoni and Mr. Heath suddenly pressured Miss Lively to simulate full nudity, despite no mention of nudity for this scene in the script, her contract, or in previous creative discussions. Mr. Baldoni insisted to Miss Lively that women give birth naked and that his wife had ripped her clothes off during labor. He claimed it was not normal for women to remain in their hospital gowns while giving birth. Ms. Lively disagreed, but felt forced into a compromise that she would be naked from below the chest down. Incidentally, this was like 6 months after she had just given birth to her fourth child. So as among these people, I feel like she would know.
Yeah.
Okay, resuming. When the birth scene was filmed, the set was chaotic, crowded, and utterly lacking in standard industry protections for filming nude scenes, such as choreographing the scene with an intimacy coordinator, having assigned nudity rider, or simply turning off the monitors so the scene was not broadcast to all crew on set and on their personal iPhones and iPad. Mr. Heath and Mr. Baldoni also failed to close the set, allowing non-essential crew to pass through while Miss Lively was mostly nude with her legs spread wide in stirrups and only a small piece of fabric covering her genitalia. Among the non-essential persons present that day was Wayfarer co-chairman Mr. Sarowitz, who flew in for one of his few set visits. Ms. Lively was not provided with anything to cover herself with between takes until after she made multiple requests. Ms. Lively became even more alarmed when Mr. Baldoni introduced his, quote, best friend to play the role of the OBGYN when ordinarily a small role of this nature would be filled by a local actor. Ms. Lively felt that the selection of Mr. Baldoni's friend for this intimate role, in which the actor's face and hands were in close proximity to her nearly nude genitalia for a birth scene, was invasive and humiliating. To add insult to injury, Mr. Heath approached Ms. Lively and her assistant on set and started playing a video of a fully nude woman with her legs spread apart. Ms. Lively thought he was showing her pornography and stopped him. Mr. Heath explained that the video was his wife giving birth. Ms. Lively was alarmed and asked Mr. Heath if his wife knew he was sharing the video, to which he replied, "She isn't weird about this stuff," as if Ms. Lively was weird for not welcoming it. Ms. Lively and her assistant excused themselves, stunned that Mr. Heath had shown them a nude video.
Yeah. And here's where I remind the listeners that Wayfarer had no human resources department. So Lively says in her complaint that there was no one to complain to or, to have walk into the sea in horror, as would, probably have been the reaction.
Yeah, this was I think, you couldn't come up with this in an HR, training on how not to do it. It would just be too far-fetched. And it wasn't only on camera that these dudes were gross and inappropriate. They made constant comments about women's bodies, including Lively's, since, as I said, she just had her fourth child. They walked into her trailer when she was breastfeeding or was having body paint removed. They talked about their sex lives. And it wasn't just Lively. Other women on the set were skeeved out, too. They just didn't have as much power as Lively. So here's more from the complaint. On May 26, 2023, Ms. Lively told a representative of Sony, that was the distributor for the film, that she wanted to file an HR complaint about both Mr. Baldoni and Mr. Heath's misconduct. The Sony representative told Ms. Lively that Sony, as the distributor of the film, was not empowered to control Mr. Baldoni or Mr. Heath's behavior on set, and that such concerns must be raised with Wayfarer, the studio responsible for the production. Wayfarer, Mr. Baldoni, and Mr. Heath received or were aware of a number of HR grievances regarding their conduct. For example, on the first day of filming, while attempting to hug Ms. Lively's employee, Mr. Heath said, "I don't even know if we're allowed to do this. It's day one, and we have an HR report already." Okay, so that was all horrible, right? So in May of 2023, production gets halted for several months by the writers and SAG-AFTRA strikes. In November, Lively's representatives negotiated a separate contract writer just for her to deal with basically everything I just read to you, so make sure none of that happened again. There was an intimacy coordinator. They closed the sets. There were going to be no more improvised sex scenes, no more commenting on her body, no more walking into her trailer, no more like sicking the personal trainer on her because they said she was fat, which is a thing that they did. And she would also have another producer on set to basically babysit the Wayfarer douche bros. And they agreed as part of this that on January 4th, before production resumed, everyone would sit down and have a come to Jesus moment where Baldoni and Heath would look Lively, and also Reynolds, who went with her, in the eye and say that they would never do any of that shit again. And they did. They had this meeting. It was in New York, which is one of the reasons that she's suing in New York. After which, they all went and finished the movie. And the movie was a big success. But the problem was, as I said, Baldoni was pretty widely disliked and nobody wanted to do press with him. And also Reynolds unfollowed him on Instagram and the fans noticed. So Baldoni, who's kind of made his career as being a manly feminist, he even has like a TED talk on how men have to stand up to sexual harassment. He started to get worried that all of this was going to come out and ruin his career. And by May of 2024, he was in a full panic. So he started strategizing with his publicist, Melissa Abel, how to best position himself as a good guy, right? So they all agreed that the PR plan for the movie was that they would promote it as a feel-good story about hope and not concentrate on, the domestic violence aspect of it, and not say like this is a gritty drama, that was more like, if you see the PR pictures, it's all sort of women in flowers and stuff. It's not supposed to be, a tearjerker. He, however, decided that it would be better to promote it for his image in the context of domestic violence because it would, prop up his feminist bona fides. At one point, he also proposed to the publicist that they would play up his neurodivergent status so that if it came out that he'd behaved badly on set, he could say it was like an impulse control issue or social awkwardness, which is also gross. So Abel, his regular publicist, brought in Melissa Nathan and her crisis PR firm, TAG, which previously represented Johnny Depp in his battle to smear Amber Heard. I guess that was successful. She certainly was smeared. It worked. But if you're calling yourself, the king of the male feminists, it's a little bit off-brand. And then TAG hired subcontractors whose actual job is to plant internet rumors, like that's their specialty. So here's something from the complaint, and I would agree this certainly looks inorganic. It says, following the August 2024 launch of Ms. Lively's hair care line Blake Brown, which she spent 7 years building, the Instagram account of the brand was flooded by harassing and derogatory comments, including many posted by user accounts that had no followers and no prior posts, suggesting inauthenticity, and which did not relate to the brand's products. To take just one example, one comment posted on the Blake Brown account by a user that, as of December 19th, shows user metrics indicating 0 posts, 0 followers, and 0 following, commented, "How about you stop paying the media to trash and smear Justin? That would be a good start, you awful human being." Another user, also with 0 posts, 0 followers, and 0 following, posted, "We want Justin's cut of the movie. He actually cares about DV, domestic violence."
Yeah, and here are more of the allegations from Lively's complaint. So she says, the scenario planning document, right, that also was produced in accordance with the subpoena, provides TAG's recommendation to get ahead of this narrative. This included suggesting misleading messaging that, 1, production members lost their jobs due to Ms. Lively's takeover and insisted upon involvement. 2, Ms. Lively involved her husband to create an imbalance of power between her and Mr. Baldoni, the producer. 3, Ms. Lively has a less than favorable reputation in the industry. And 4, Ms. Lively had a clear, likely motive to bully her way into buying the rights for It Starts With Us, the sequel to the film currently owned by Wayfarer. The scenario planning document states that TAG could, quote, also explore planting stories about the weaponization of feminism and how people in Blake Lively's circle like Taylor Swift have been accused of utilizing these tactics to bully into getting what they want.
I cannot even.
Upon review of the scenario planning document, Baldoni informed Heath that he was not in love with the document they sent, but not for the reasons you think. Not sure I'm feeling the protection I felt on the call. Heath responded, that's the most important part of this is how quickly they can shut things down and place stories in your favor. And the complaint continues. Later that same day, Ms. Abel conveyed to Ms. Nathan that Baldoni was questioning whether the plan was aggressive enough, texting that Baldoni wanted to feel like Ms. Lively could be buried. Ms. Nathan responds, of course, but when we send over the documents, we can't send over the work, will or could do, because that could get us in a lot of trouble. We can't write it down to him. We can't write. We will destroy her. Imagine if a document saying all the things that he wants ends up in the wrong hands.
I mean, can you even imagine?
In fact, I can't. I don't have to, because Blake Lively's lawyers seem to have kicked their stuff loose with not too much difficulty.
Yeah, those texts are amazing. Also, Melissa Nathan's sister, Sarah Nathan, writes for the New York Post. And there's, Melissa's texting Abel about working her own sister to massage the stories. And Nathan and Abel are telling the Daily Mail and Us Weekly that Lively bullies other female actors, the whole weaponization of feminism thing. And meanwhile, they're silently behind the scenes congratulating themselves for not getting their client canceled and even talking about what a sleaze he is. So Nathan says in October, he doesn't realize how lucky he is right now. We need to press on him just how fucking lucky. The whispering in the ear, the sexual connotations, like Jesus fucking Christ. Other members feeling uncomfortable watching it. I mean, there is just so much, which was clearly a reference to the volume of inappropriate behavior which Baldoni had engaged in front of, the cast and crew. And Abel says that fans, quote, believe the issue of the feud is because she took control of the movie, which she did, actually. Lively hired her own staff and recut it, and she added a Taylor Swift song. And Sony liked her version better, and that's actually what got released. And maybe that didn't result in some bad feelings, but that's not what went wrong between her and Baldoni, obviously. At one point, they discussed over text sort of fan chatter saying that Lively should divorce Reynolds because he made her take over the movie and recut it and was ruining her reputation. And Nathan texts Abel, it's actually sad because it just shows you have people really want to hate on women. And yes, it is. And they were participating in making it happen. Lively is an experienced professional, and they got people to write about her. She had no agency. She was just smearing Baldoni and ruining her career because of mean Ryan Reynolds, her husband. It's a lot. But we'll come back to it in just one sec after we take another ad break, unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, not for you.
And we're back. Okay, let's talk about the alleged torts here, because there are a lot of them, 13 to be exact. So the biggest one is sexual harassment under Title VII. Lively says that Baldoni, Heath, and Wayfarer created a hostile work environment, which seems supported by the allegations, right? And then she says that they retaliated against her, which is a more interesting question, right? So here's the allegation. She says, after Ms. Lively engaged in such protected activity, right, that was insisting that they bring in the intimacy coordinator and make changes on the sets, defendants subjected Ms. Lively to adverse employment action, including but not limited to by launching a coordinated campaign to cast Ms. Lively in a false light during the publicity and promotion of the film and thereafter. Ms. Lively's protected activity was the motivating reason for and the but-for cause of defendants' conduct. This harassing and retaliatory conduct continued in various forms throughout 2024 and, on information and belief, is continuing in order to discredit her in the event that she publicly disclosed her concerns about harassment and other unlawful conduct and to irreparably damage Ms. Lively's career and future earning capabilities. And look, I'm not an employment lawyer in this context, right? But I can see an argument from the other side that although what Baldoni and Heath and the others did was certainly retaliatory in the ordinary English sense of the word, the smear campaign, you could argue, wasn't legal retaliation for reporting the harassment, right? It was proactively trying to discredit her if she talked about it, which is not exactly a tight fit, right? I'm not saying that it isn't, but typically retaliation is when your employer fires you or gives you the worst shifts or refuses to promote you or whatever, right? Takes what is in the case law called an adverse action after you allege sexual harassment. And I'm just flagging this because you might see an early partial motion to dismiss. And as you've said, Liz, there are already a ton of negative stories about Blake Lively out there. So if you see that, right, I mean, I don't fault her lawyers for making these allegations, but that's a complex legal question. Now, Lively also alleges multiple violations of California state labor laws. She alleges intentional and negligent infliction of emotional distress, false light invasion of privacy, breach of contract, since the writer that they executed explicitly said they wouldn't retaliate against her, and that's in a broader sense, really, including in post-production. So there's a lot. The case seems meritorious. It is certainly supported by these thousands of text messages. That's Lively's New York suit. Now, I want to talk about the complaint that was filed on the same day, Baldoni's lawsuit against the New York Times, because this one was dead on arrival as it was being filed.
This is not a real lawsuit. This is a Sasquatch lawsuit.
Yeah, it's true. But there is a part that's very, very funny in the be careful what you wish for sense, right? Because, look, Baldoni has in his employ a super aggressive media lawyer out there, filing defamation lawsuits. So, we're going to be a little bit careful here. and we're not going to characterize what he did. We're instead going to read from Baldoni's own complaint directly, starting with paragraph 3, where he says, "The Times participated actively in the legal maneuvering at the heart of Blake Lively's strategy. Notably, Lively chose not to file a lawsuit against Baldoni, Wayfarer, or any of the plaintiffs, a choice that spared her from the scrutiny of the discovery process, including answering questions under oath and producing her communications. That decision was no accident. First, her administrative complaint," right, that's the one before the California Civil Rights Commission, "is rife with blatant falsehoods and egregious misrepresentations that would have subjected her to dismissal if not sanctions. Second, pursuing formal legal action would have derailed her true objective, an orchestrated campaign to rehabilitate her public image."
Well, that one aged like proverbial milk because, as you said, literally at the same time that Baldoni's lawyer was complaining in California court that Blake Lively absolutely never really intended to sue anyone, it was all a PR stunt, she was filing her lawsuit against his client in New York. Whoopsie.
Yeah, and look, none of this introductory stuff has anything to do with defamation, right? So you can see, though, that Baldoni's lawyer thought he was being clever by calling out the, unique procedural posture that resulted in Blake Lively having text messages before filing her lawsuit rather than getting them in discovery, which, is the normal course, right? So the complaint continues. Instead, Lively filed a request for a right to sue letter with the California Civil Rights Department. A procedural formality that does not require pleadings, remains confidential unless leaked as it was here, and crucially does not subject the complainant to discovery. While such a letter can precede a lawsuit, it is clear that litigation was never her ultimate goal. Her real intention was to weaponize the appearance of legitimacy conferred by a numbered legal document to launch salacious, headline-grabbing allegations and reshape her public persona at the expense of the plaintiffs.
Yeah, it's interesting to accuse somebody of filing a lawsuit-shaped object in, let's just say it's maybe a little ironic. Anyway, time to pull that pin because here's where Stephanie Jones re-enters the chat. Remember her? She's the former Baldoni Wayfarer publicist they fired after they hired the crisis outfit. Baldoni's argument is that the subpoena Lively served on Jones Works was actually a friendly subpoena so that Stephanie Jones would sort of have to, wink, wink, turn over text to Lively in violation of her non-disclosure order with Wayfarer that kicked in when she was fired. And then Lively would be free to leak those texts to the press without filing a suit, just to smear poor defenseless Justin Baldoni, which is a cool conspiracy theory, bro. Except that Lively did file suit, so obviously she wasn't trying to duck discovery or whatever bullshit that he was saying. And we definitely have not heard the last of Stephanie Jones and Jones Works. She's also suing Baldoni. She's had a lot of very high-profile clients, and she's also got this kind of outsized reputation as a hell boss. And, look, people talk shit about women with power a lot. I don't know, but the texts do not paint her as a shrinking violet, let's say. So she litigates the way she practices PR. This is going to be something to behold.
Yeah, well, even without Baldoni's lawsuit imploding because he guessed spectacularly wrong as to Blake Lively's motivations, this complaint was never going anywhere in the first place, right? And the reason from a legal perspective why it's DOA is actually, I think, the motivation for Baldoni filing the complaint in the first place. So let's unpack that. The principle that comes into play here is called the fair reporting privilege. It's something, Liz, you and I have talked a lot about in the context of Donald Trump's many, many, many garbage defamation suits, right? So the fair reporting privilege is not a constitutional First Amendment right? It's not like New York Times v. Sullivan. Instead, it's up to the states. It's a series of state laws. But as a matter of public policy, most states have decided that journalists should enjoy a form of immunity from defamation, from legal liability for reporting on court cases. And of the two states' laws that could potentially apply here, very likely California or, less likely New York, both of them recognize this privilege.
Yeah, so it's California Civil Code Section 47D, and it says a privileged publication or broadcast is one made by a fair and true report in or communication to a public journal of a judicial, legislative, or other public official proceeding or anything said in the course thereof. So there you go. And New York Civil Rights Law Section 74 is similar. It says a civil action cannot be maintained against any person, firm, or corporation for the publication of a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding, or for any heading of the report, which is a fair and true head note of the statement published.
Right. So don't take legal advice from a podcast or anything, but that privilege essentially means that we as journalists can repeat anything that's in a complaint, right? Like that's fair and true report. And those laws do have exceptions if you mischaracterized it or for court filings where the filings themselves violate the rules of professional conduct and things like that. But look, we know sanctionable, like that's a low bar to clear, right? So you can see how the fair reporting privilege could be a double-edged sword, right? Like, look, we definitely want newspapers to be able to say Blake Lively has sued Justin Baldoni alleging she was sexually harassed on the set of their latest movie because that's newsworthy and it's true. She did, right? But at the same time, like, you don't have to squint to see the potential for abuse here, right? Like, bad faith actors could file nonsense lawsuits, say, claiming that the 2020 election was stolen. And then bad faith news outlets can then gleefully report otherwise defamatory claims that are raised in those lawsuits as if they were true, which, explains really large percentage of Trump's lawsuits over the last 8 years, right? Like they're just a rage tweet attached to a $402 federal filing fee and flung at the federal docket like a, flaming bag of dog do.
Yeah. Interesting phrasing there. But you're right. Courts do not like serving as a billboard for bullshit claims. That's why North Carolina has that rule that you can't specify damages in the pleading if it's more than $10,000 because they didn't want Mark Robinson, the lieutenant governor or the former lieutenant governor, doing exactly what he did, which was to file that defamation suit against CNN and then march out to hold a press conference outside the courthouse saying that he was suing CNN for infinity billion dollars. And, and that entitled him to like all of the sweet, sweet earned media he could feast on. Look, to be fair, Baldoni's complaint is realer than Robinson's, and he certainly has experienced counsel, Baldoni, that is. But to me, it reads as yet another PR ploy, a way to kind of get the media to cover his side of the story and make it a he said, she said thing, which I don't think is going to work for reasons that we'll get into. But okay, the complaint alleges 4 counts of action against the New York Times, 1 for defamation, 1 for invasion of privacy, and 2 for fraud and breach of contract. Which, can we just start with, how the hell does he have a contract with the New York Times?
You guys, Liz was so excited when she got to this part of the complaint. So we will get into that after this brief ad break.
And we're back. Okay, so in Baldoni's complaint, he alleges an implied in fact contract in which, quote, the Times would refrain from publication of the Blake Lively story for a brief period in exchange for a substantive response to the allegations, additional relevant information, and confirmation of the authenticity, accuracy, and completeness of the relied upon communications. And he alleges that the Times breached that contract by publishing the story early. I mean, which is creative. I'm going to give him that one. Except it does not appear to be what happened at all. Like, not even the way Baldoni tells it. So, all right, again, we'll read from this complaint. At 9:43 p.m. Eastern Time on December 20th, 2024, Times reporter Megan Twohy requested plaintiff's response to its reporting regarding, quote, a crisis communications operation conducted on behalf of Justin Baldoni, Jamie Heath, and Wayfarer Studios to protect their reputations and harm Blake Lively's, as described in a legal complaint filed today. So I guess they think it was filed on the 20th. Quote, we are seeking your response to the claims of retaliation through this PR campaign, and we would welcome the opportunity to talk with you on the record. Please offer any on-the-record comment as well as any other information you think we should know. Additionally, please notify us of any inaccuracies. We need to hear back from you by noon Eastern.
Yeah, so right off the bat, that's not a contract, implied or otherwise, right? Like, a contract must have, as one of its elements, mutuality of obligations, right? Promises on both sides. And you will notice the Times did not promise to do anything, right? It said, hey, Justin Baldoni, we would like to hear from you before noon tomorrow.
Which Baldoni's team did, right? At 2:16 a.m., presumably Eastern Time, plaintiffs' legal representatives responded with a denial, which, okay, whatever. And then at 10:11 a.m. the next day, the Times published the article.
Yeah, there's a lot here, right? So first, just having a denial from the other side does not satisfy the New York Times v. Sullivan pleading standard for showing actual malice against a public figure that's necessary to bring a defamation claim, right? Like, in other words, just because Baldoni's side said, hey, this bad thing that you're going to print about me isn't true, does not obligate the New York Times to say, oh, well, you said it's not true. I definitely won't print it then, right? Like, you need more to satisfy actual malice, that is, knowing falsity or reckless disregard of the truth or falsity of the statement. And like, a general denial just isn't it. Second, it's kind of mind-boggling to think that even if this back and forth, right, like totally standard between press and target of a story, like even if you could construe that as some sort of promise to embargo the story until noon, which is, you know, how they're characterized, but, and like, which it definitely was not, like we just read it to you, but even if it were, publishing the story less than 2 hours early and after Baldoni's team had the chance to provide the requested commentary, you know, the denial they asked for. Like, how could that possibly have damaged him in any way? Like, certainly in a contractual sense. Like, what were they going to do with those extra 109 minutes that they alleged they were deprived of?
Yeah, I mean, look, here's their argument. They say, as a direct and proximate result of defendants' foregoing breach, plaintiffs were deprived of the benefits of the bargain in that they lost the opportunity to meaningfully assess and respond to a false, misleading, extremely inflammatory portrayal of their actions and character. And like, this is the thing that gets me about this complaint. First of all, they say, we responded, and that's how we get actual malice. We responded, we told you that the story was wrong, and thus you had actual knowledge of the falsity of your story. And also they say, you didn't give us a chance to respond, and you breached the contract. Like, I mean, which one is it? Is it that you responded and they, you know, printed it and they shouldn't have printed it? Or is it that you didn't respond and they breached the contract by not giving you time to respond? I mean, it clearly can't be both. And I mean, frankly, it's neither. But to have a complaint so internally inconsistent and self-contradictory is like, what are you even doing here?
Yeah, well, you're really going to love the defamation and invasion of privacy counts, right? Because this complaint, like many garbage complaints, does not allege that a single thing the New York Times printed was false, right? And here is, yeah, look, like, here's a little practice tip to figure out whether you should take a defamation complaint seriously or not, right? Like, a facially plausible one, right? This is a very low bar to clear, will have defamatory statements as a defined term, capitalized, and set out in a fact section, right? In a paragraph. That paragraph will then quote, word for word, exactly what the plaintiff claims were false statements.
Right. Like, we told you that Trump's lawsuit against ABC and George Stephanopoulos wasn't his regular garden variety troll suit, like the ones about the Pulitzer Prize Committee or, when he sued CNN. He sued a lot of people, and most of that was garbage. But here, Stephanopoulos was stupid enough to say multiple times that a jury had found Trump liable for rape, which it did not. And that's why it was pled with like a list of all of the times that Stephanopoulos had said it. That was a real complaint.
Right. And look, to be clear, that's not saying we think Trump would have won on that lawsuit or anything, right? Like, that's just identifying the actual statements that are claimed to be false is kind of the minimum threshold for taking a complaint seriously. And as you said, this complaint does not identify any false statements. In fact, the first mention of the word statements, and I did Control F for synonyms, that comes on page 79 of the 85-page complaint. It's paragraph 124. It's in the enumerated causes of action, right? Like where you're sort of making the recitals necessary to survive the pleading requirements, right? And it just says, the article contains fabricated, false, malicious, and defamatory statements of facts concerning plaintiffs. What are those statements, you might ask? Well, it's all vibes, man, right? Because like the next paragraph says, the article is libelous on its face and exposes plaintiffs to hatred, contempt, ridicule, and obloquy, causes plaintiffs to be shunned or avoided, and has a tendency to injure them in their occupation.
Ooh, obloquy. Somebody got a word a day calendar for Christmas. I had to look it up myself.
Really?
Yes, I
did. Continues. Specifically, the article falsely attributes negative public sentiment towards Lively to a malicious, premeditated, affirmative smear campaign orchestrated by plaintiffs, and not to Lively's long-standing reputational challenges and the whims of a fickle and sometimes cruel online public.
Oh, my God.
Yeah. So did translate to English. Like, this is just the Alan Dershowitz. Unless you play all 7 minutes of my answer, it's libel. Like, no, it isn't, Alan. Like, this argument gets raised all the time. It never wins. The false statements that they claim are that the New York Times republished text messages from Lively's complaint out of context. And so then this complaint has like 30 or so pages showing additional texts and these annotations. And it's kind of baffling to read, actually.
Yeah. And look, one of the things that they complain about is that they left out an emoji or something,
Right.
which
a little upside down smiley.
Yeah, upside, right. And that, remember, we talked for a long time here today about the fair reporting privilege. And so if they were quoting what Lively put in their complaint as she put it in there, they're covered under that, right? And if they want to argue in court against Blake Lively that the text messages don't show what she claims they show because they're taken out of context, that's fine. That is one way in which defamation claims are litigated. But it's not an argument that they were defamed by the New York Times.
Right.
Baldoni says the Times uncritically embraced Lively's civil rights complaint as fact and disregarded the plaintiff's emphatic objections, rushed to publish its inflammatory article, and rather than striving for accuracy and balance, prioritized hollow signaling over substantive reporting, further eroding its credibility and exacerbating the very mistrust it claims to combat, blah, blah, blah. And you know what? I don't think that's true. But even if it's true, it's not defamation.
Yeah. To kind of steal about the other side, I went back to the Times article line by line to see if there was anything in it that would not be covered by the fair reporting privilege. And, right, that would be something saying that Lively's underlying claims are independently true rather than they're just what she's said in a court document, right? And so if you were going to make that argument, here's the place where you would make it, right? So quoting from the Times article, it says, there have long been figures behind the scenes shaping public opinion about celebrities through gossip columns, tabloids, and strategic interviews. The documents show an additional playbook for waging a largely undetectable smear campaign in the digital era. While the film about domestic violence was a box office hit, making nearly $350 million worldwide, online criticism of the actress skyrocketed. He wants to feel like she can be buried, a publicist working with the studio and Mr. Baldoni wrote in an August 2 message to the crisis management expert Melissa Nathan. We can bury anyone, Ms. Nathan wrote in response. So here's the thing that struck me, even as we drill down into the specifics of this argument. While there are dozens of pages saying that Lively, left this message or that message out or omitted the emoji or whatever, there is absolutely nothing in Baldoni's complaint that suggests that there is any other context to that text exchange of, we can bury anyone, right? And that is the incendiary claim of the article, right? But Baldoni just says, well, if you read all the text messages, it will refute any allegation that they intended to bury Blake Lively. And, Liz, as you said, okay, make that in court. But those documents do show what the Times said, which was an additional playbook for waging a smear campaign.
Yeah, I don't think they're going to be making that argument in any courts. I mean, they might be making it in a court in New York to defend themselves, but they're not going to be making it offensively.
Yeah.
Okay. As we said, this lawsuit is filed by a very experienced PR media celebrity lawyer in California who, I would infer that he isn't doing this by the seat of his pants.
Yeah, he's not Alina Habba. And look, I think that there certainly is strategic thought going on, right? And so one example of something that, got me curious was they filed in state court. Mm-hmm. And yet, on the face of the complaint, there is complete diversity, right, between all of the parties. They didn't try fraudulent joinder to add somebody who was also a California, right? And so what that means is the very first thing that the New York Times is going to do is remove the case to federal court.
Yeah, and I see where you're going, right? Are these cases going to be combined? And if so, where? Is Baldoni just trying to get into California by saying okay, I got in first, and if these cases are going to be joined, they're going to be joined in California. That's where most of the stuff happened. As we said, most of Lively's claims are state employment law claims. But Baldoni isn't suing Lively. He's only suing the New York Times. Obviously, there are the Doe's 1 through 100 inclusive. That's kind of your boilerplate language that you stick in there and say and some other people to be named later. But it's not like he can add Lively later and say I just didn't know her name. This is not the same lawsuit.
She's not a Doe. Yeah.
Right. It's not the same lawsuit. And so I'm not entirely clear if there was a plan to get them joined, for them to put an anchor in California, wouldn't they have had to sue Lively? I don't know.
Yeah. I think it is. I think, what you're implying is that they're trying to resist consolidating. I don't know what the strategy is for maintaining two separate lawsuits, but it certainly seems like a strategic decision not to add her to the complaint.
Right. And just one more thing. California has a very strong slap suit. I don't why would you file this? I understand that we've talked about filing lawsuits as a PR mechanism, but California is not a place that I would try that shit.
Yeah, although, the law isn't great in New York either. And, we are talking procedurally, and procedurally, California's anti-SLAPP law would apply even in federal court. You're absolutely right. And that, causes me to wonder, right? My initial read on Blake Lively having filed in federal court in New York was that Baldoni was going to move for a change of venue, which, he would have a good argument for that, right? Because I can tell you, I'm not sure that the Southern District of New York is where that complaint should be heard, right? Given that she asserts that California law applies to the conduct that occurred on the movie set in California. Right? I'm not saying that it was improperly filed in New York. Yeah, it clearly meets the minimum.
Right. She's saying that Ryder meeting, the meeting on January 4th, 2024, where they had their come to Jesus moment, that took place in New York, and she says that's why there's venue in New York.
Yeah, and I think that probably satisfies the venue statute, 28 U.S.C. 1391b. But what that means is that if Baldoni tries to move the case to California, that will be a discretionary motion before Judge Lyman for a change of venue. The standard there is 28 U.S.C. 1404a, and it says, for the convenience of parties and witnesses in the interests of justice, a district court may transfer any civil action to any other district or division where it might have been brought, or to any district or division to which all parties have consented. And the case could have been brought in federal court in California. So, it'll be up to Judge Lyman's discretion. We'll see if there is such a motion, and if so, what he does.
Yeah, I can't. Why would they let it go to trial? Pay somebody. This. Why? I know that we just watched Donald Trump go to trial against Eugene Carroll instead of giving her, some amount of money. Any amount of money would have been better than what he's going to wind up having to pay her. But we'll keep an eye on it. It's a wild one.
Yeah. Okay. Well, That was heavy, but in lighter news, Liz, did you know that I have fatwas issued against me by the Ayatollah personally?
Is that why you let your driver's license expire? No, I'm kidding. But Rudy Giuliani was not kidding when he said that. I mean, it was a stupid excuse, but that was his explanation in deposition last week for why he failed to renew his driver's license in New York. Remember, he's got a contempt hearing on Friday the 3rd. That's the day this show drops, for failing to cooperate with the turnover order in the collection case filed by Ruby Freeman and Shay Moss, because you will not get full credit for handing over your car and not the title that would allow your creditors to sell it for cash money. And he seems to think that he should. And I know I've said so many times that we have to stop doing Rudy in the Patreon bonus, but I cannot help it because it is just too funny. And so if you are a subscriber at any level on patreon.com/lawandchaospod or lawandchaospod.com, stick around. It's going to be a funny one.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.